Welcome back. We received a really high-stakes piece today. It's a fierce defense of a political figure that argues systemic corruption is undermining Israel's entire legal system. So let's just jump right in.
Okay.
The first thing that really stands out is the overall structure. The central idea, that there's deep political corruption in the justice system, it's a powerful one.
It is.
But I feel like it's getting diluted because it's chasing too many different, very complex legal fights all at the same time.
I get that instinct, though. You can feel the writer wanting to expose every single instance of what they see as rot.
Exactly.
But in doing that, the whole thing starts to fracture. I mean, it jumps from the High Court's authority on appointments to these internal integrity issues with the AG and police officials, then over to presidential pardons, and then the whole thing with Gailey Tzahal.
Yes, and each one of those is massive. Each one needs its own history, its own context, and the reader is just constantly having to switch gears.
And the result is it feels scattered. It doesn't feel like a single, cohesive pattern of abuse. It loses that narrative thread.
The spine. It loses its narrative spine.
That's it. It's the classic breadth versus depth problem. So I guess my question is there one allegation in here that's just so concrete, so verifiable, that it can anchor the whole piece?
There is, and I think that's the key. The suggestion here is to pick the single most potent example of misconduct you've got.
And build the whole case around that one point.
Right. Use the other issues as just brief, supporting evidence, just to show the scope of the problem. That would make it so much clearer, so much more impactful.
Okay, so which one is it? Which is the anchor?
For me, it has to be the claim that the Attorney General wrote a false declaration to the court. The part that says no further investigative actions were needed, when the writer claims, and this is key, that not even one investigative action had been performed.
Oh, that's gold. Yeah, that's a direct, factual claim. It's not about interpretation. It's about a statement versus, allegedly, an action.
Exactly. So what if, say, 80% of the narrative was focused just on that disparity? That's way more powerful than trying to debate the statutes around closing a military radio station.
I completely agree. And then those other issues become contextual illustrations, like with Galilei Tzaha. Instead of a whole long section, it's just a quick line.
Something like, this same disregard for due process is also evident when the High Court exceeds its mandate in political areas like media regulation. It turns a whole separate trial into a quick footnote.
So it sharpens the focus from just, here's a list of things they're doing wrong, to this is how they specifically committed fraud. And here are other examples of their overreach.
You lead with the knockout punch.
Yeah, that makes sense. Okay.
So that focus would really streamline the experience. But speaking of experience, we have to talk about the personal testimony in this piece. It's incredibly compelling.
It is.
But while it creates this real sense of urgency, the detailed anecdotes, about the courtroom conflicts, they need to be synthesized. They have to serve the larger critique, not just stand there as sort of standalone grievances.
Okay, but hold on. Let me just play devil's advocate for a second.
Go for it.
The writer includes these very vivid descriptions, right? Justice Wilner's arrogant remarks, someone cursing me in my ear, the judge asking her to move seats. If you strip out that raw emotional fire, don't you risk flattening the whole thing? I mean, that urgency feels intentional.
Oh, it's a strength, no question. But we have to manage the pace. These moments, as vivid as they are, they slow the momentum of the core legal argument.
I see.
The risk is that the audience starts focusing on the personal drama, the advocate being disrespected, instead of the actual systemic failure, like the alleged corruption between AG Miri and Officer Tsaban.
Right. So it's an editorial challenge. The suggestion isn't to remove them, but to reframe them.
Exactly. You synthesize them into concise illustrations of a pattern of bias. The anecdotes need to be the setup for the legal point, not a detour from it.
I see. So you use the anecdote as a springboard.
A springboard to the structural flaw. So for the Wilner confrontation, instead of just describing the disrespect, you frame it. You say something like, the courtroom environment itself was openly biased, which perfectly parallels their disregard for the rule of law on much bigger issues.
That's much stronger. Or, okay, what about the part where she challenges Justice Amit for calling Marwan Barghouti the prisoner?
Same idea. Instead of letting it just hang there as a moral point, you pivot quickly. You make it an example of a profound ideological failure, which, indicates the court's predisposition in other big political cases.
So it takes that deeply felt personal experience
and transforms it into concrete evidence that feeds the main thesis. It honors the passion, but directs it.
Got it. You're making sure every emotional beat actually builds the legal case.
Exact. Which brings us, I think, to the third and final point. It's all about tone, about calibrating it for maximum persuasion.
Okay.
The language is often very absolute, very emotionally charged. And while that definitely fires up supporters, it also risks having the whole thing dismissed as just, a political rant. It limits who you can persuade.
Yeah, that's a tough line to walk, isn't it? Because the passion is real, but the material is just saturated with phrases like, the prosecutor is lying, shameful corruption, enemies from within.
And if the goal is to convince people who are still on the fence, the jury, not just the choir, that kind of tone can backfire.
For sure. People who want facts and evidence tend to shut down when they hear that kind of hyper-partisan rhetoric. The moment you say they are all contaminated, you invite a skeptic to just dismiss the entire thing.
So the suggestion is to strategically swap those blanket accusations for concrete, demonstrable fact. You let the evidence carry the weight of the accusation.
So let the reader get angry on their own.
Yes, focus on actions that violate protocol or represent a conflict of interest. The reader should reach the emotional conclusion based on the facts you lay out.
Okay, let's take a concrete example. The section on Boaz Balad. Instead of saying, I know why they hold him there, which, a reader can't verify.
Right. You pivot to specific, actionable demands based on what he allegedly didn't do.
So it becomes, Balad must be required to explain why he hasn't taken the AG's phone, or issued a warrant for communication research, or investigated that meeting.
That list of specific, omitted actions is so much more incriminating. It demands accountability.
It really is. And same thing with the pardon discussion with Trump and Herzog. The draft gets very emotional, right? I refuse that the PM should grovel.
And you can strengthen that instantly by shifting away from the emotion and focusing purely on the legal grounds.
On the precedent.
Exactly. Talk about Case 300, how it confirms the president has absolute authority to grant a pardon even before a conviction. It grounds the political argument in case law, which is far more persuasive.
That reframing makes the whole thing feel more rigorous. It shows the passion is backed up by, receipts, by precise legal facts. And for a critique like this to be taken seriously by a wider audience, that's what it needs.
Absolutely. Okay, this has been really productive. I think we should briefly recap the key takeaways for the writer.
Sounds good.
So, first, we're strongly suggesting you streamline the whole narrative. Focus everything around that strongest, most specific claim, that alleged false declaration to the court.
And make all the other claims just secondary evidence of the scope of the problem.
Second, take those powerful personal experiences in the court. Don't remove them, but frame them as contextual evidence of systemic bias. They need to support the main argument, not slow it down.
Right. They become springboards, not detours.
And finally, a big one is calibrating the voice. Replace the broad, sweeping accusations with precise, demonstrable facts. Let the evidence itself do the heavy lifting.
Yeah, let the facts convince the skeptic. The passion and the deep knowledge in this piece are undeniable. They're a fantastic foundation. If you just refine that focus and let the facts speak for themselves, this could be an incredibly powerful argument.
I agree. We're really looking forward to seeing the revision. Please send it back to us when it's ready.